want to say thank you to the organizers for the possibility to present a part of my dissertation at this conference. A few words to myself. I'm Benedikt Hirschler. I'm a university assistant at the Vienna University of Economics and Business at the Institute for Business Law. And we take a big step from Spain, warm Spain, to the cold Austria, and also from legal history to the advisory board. My topic of my dissertation is the advisory board in family businesses, and today I'm glad to present you in the next approximately 25 minutes about the possible tasks of an advisory board in different family businesses. Before I go into the legal part of my presentation, I would like to briefly outline the factual significance of an advisory board in medium-sized companies. There are studies in Germany that show about 50 to 65% of the medium-sized companies already have an advisory board. In Austria, only 20%, and there's only one study from 2013, I think. Yeah, to today's agenda. At first, I want to show you the different types of the advisory board, and then focus on the GmbH. What this is it's a limited liability company, and on the partnerships. And at the end, I want to show you the special tasks of the advisory board in the family businesses. So, first of all, there is neither explicit legal basis for the establishment of an advisory board in Austrian corporate law, as well as there's no definition of the advisory board. I will show you that it's possible and allowed to establish one, but firstly, there has to be made a distinction between two different ways of establishing an advisory board. On the one hand, you have an advisory board as an additional body, and on the other hand, you can also establish an advisory board under the law of obligations. Focus on the advisory board as an optional body. The establishment of an additional body in the GmbH arises from the fact that Section 20, Para 2 of the GmbH Act mentions further bodies without naming directly the advisory board. However, an advisory board can not only be established in a GmbH, but also in all other corporate forms due to the private autonomy. Depending on the tasks and function assigned to the advisory board, a distinction can be made between an advisory board that is close to the directors, close to the supervisory board, or close to the shareholders. The tasks that can be transferred depend not only on the organizational basis, on the basis on which the advisory board is established, but also on the corporate form. The articles of association must define the tasks that are transferred to the advisory board, and the advisory board regulations can then specify these tasks. However, an advisory board can not only be established as an additional body, but also under the law of obligations. An advisory board under the law of obligations has no rights or obligations like a corporate body, of course. Generally, only advisory functions are assigned to such an advisory board. It is disputed whether the advisory board under the law of obligations may also be assigned supervisory tasks. While an advisory board under corporate law as an additional body can only be established by the shareholders due to the necessary provisions in the articles of association. An advisory board under the law of obligation can also be established by the directors. But I don't want to go into detail about the advisory board under the law of obligations. but instead focus on the advisory board as an optional body because this is more interesting. So the same regulations for GmbH and partnerships are applicable for the advisory board under the law of obligations. So focus at first on the GmbH. The advisory board as an additional body in a GmbH close to the shareholders fulfills those tasks that would be fulfilled by the shareholders without a corresponding regulation in the Articles of Association. The advisory board can be directly assigned dispositive shareholder competences as well as rights of approval. The rights of approval may also only relate to dispositive responsibilities. Examples, sorry, it was one, this previous wasn't that, it only shows that it says this section 20 paragraph 2, so it's completely forget this slide. The examples examples that can be transferred to an advisory board are the right to issue instructions to the directors as well as the right of approval to the transfer of shares. However, there are mandatory competences of the general meeting. The general meeting is the supreme body of the GmbH. The jurisdiction over jurisdiction in German, it's called Kompetenz, is the expression of the general meeting as the supreme body of the GmbH. The general meeting can abolish the advisory board or withdraw the tasks assigned to it at any time based on this jurisdiction over jurisdiction. Also, the amendment of articles concerns as a mandatory competence of the shareholders. The principle of autonomy of association stipulates that the essential decisions concerning the company, example, the amendment of the articles of association or the decision to dissolve the company, must be decided by the shareholders themselves. The exclusive competence may not be limited by the agreement of an additional approval of the advisory board. This would grant the advisory board an unauthorized veto over the general meeting when amending the articles of association. Furthermore, the appointment of directors is one of the most important competences of the shareholders. In the past, it was disputed whether this task can be transferred to an advisory board or a supervisory board. Now, the unanimous opinion as well as the jurisdiction assume a mandatory competence of the general meeting. Although the GmbH Act does not explicitly standardize that the appointment of directors is a mandatory responsibility of the general meeting, the draft legislation of the GmbH Act provided the appointment of directors as a mandatory decision, mandatory competence of the shareholders in section 35 para 2 of the GmbH Act. However, this was removed before submitted to Parliament as the historical legislator assumed that this mandatory task would always would anyway result from section 15 para 1 of the GmbH Act that regulates the appointment of the directors. The purpose of standardizing the appointment of director as a mandatory competence serves to strengthen the general meeting as the supreme body of the GmbH. This is a special feature of the GmbH compared to a stock company that the shareholders can directly intervene in the operational business of the GmbH by appointing the directors. In principle, the exclusion of shareholders is also an exclusive responsibility of the general meeting. For the GmbH, the exclusion of shareholders is only explicitly regulated in the Squeeze-Out Act. According to the Squeeze-Out Act, a minority shareholder can be excluded at the request of the majority shareholder, who has to own at least 90% of the shares, and there has to be a simple majority of the votes cast at the general meeting, as well as the majority shareholder consents. Although the majority shareholder has to own 90% of the shares and he has to consent, the mandatory resolution requirement is necessary for the legal clarity and also legal protection due to the possibility of contesting the resolution. The mandatory participation of the shareholders in the decision serves as a shareholder protection instrument. I already explained that in the case of mandatory responsibilities of the general meeting, no rights of approval may be transferred to an additional body. However, in the case of the exclusion of shareholders under the Squeeze-Out Act, minority shareholders should be protected. Minority protection is strengthened by the approval of an additional body, but without inadmissibly interfering with the sole decision-making authority of the general meeting. Because of Section 1, Paragraph 4 of the Squeeze-Out Act, the admissibility of the squeeze-out can be excluded by the Articles of Association, which means that the right of approval of an advisory board does not disproportionately interfere with the rights of the majority shareholder. An advisory board, therefore, be granted a right of approval for shareholder exclusions in accordance with the Squeeze-Out Act. Those tasks of the general meeting that are standardized in Section 35, Paragraph 2 of the GmbH Act may not be transferred to an advisory board, as these responsibilities are explicitly mandatory competences of the general meeting. This includes the approval of annual financial statements as well as the discharge of the directors. In any case, the advisory board can act in a supportive or advisory manner, regardless if it is mandatory competence. The sole decision-making right of the shareholders is not affected in the case of mere consultations or preparatory actions by the advisory board, which means that the decision-making authority remains to the shareholders, or with the shareholders. So, I show you, here are a few clauses that are in any case inadmissible: the appointment of the directors, or also the right of approval in the case of amending the Articles of Association, as well as the discharge of the directors. The advisory board close to the directors. Almost all management tasks may be transferred to the advisory board. These only concern the internal relationship of the company, which means which can be organized relatively freely. However, it is inadmissible if the directors are delegated or degraded to a mere executive body that is not allowed to show any initiative of its own. Otherwise, an advisory board can be granted both direct management powers and comprehensive rights of approval that go beyond a sole monitoring function. The legally standardized judicial and extrajudicial representation monopoly of the directors may not be transferred to an advisory board. In principle, the advisory board is purely an internal body. So, to the advisory board close to the supervisory board. An advisory board close to the supervisory board fulfills tasks in place or alongside a supervisory board that are generally fulfilled only by the supervisory board. In the case of an advisory board close to the supervisory board, a distinction must be made if there is a supervisory board in the GmbH. It is important to ensure that the employee participation regulations are taken into account when exercising the core tasks of the supervisory board. The employee participation provisions are safeguarded by the 1/3 parity on the supervisory board. For every 2 shareholder representatives, 1 employee representative is delegated to the supervisory board by the Works Council. If there is a supervisory board and they're only concurrent or and not displacing competences, the employee co-determinations are taken into account at the level of the supervisory board. Which is why there is no need for 1/3 parity on the advisory board. In the case of concurrent responsibilities, the supervisory board has a veto anyway, as rights of approval need the consent of the advisory board as well as the supervisory board. However, if there is no supervisory board and the core tasks of a supervisory board are transferred to an advisory board, the mandatory statutory provisions of the supervisory board are directly applicable to the advisory board. The core functions of the supervisory board include the rights of approval under 30G, under Section 30G, Para 5 of the GmbH Acts, in particular the acquisition and sale of participation or of real estates. And of course, the comprehensive control and monitoring tasks. In the case, 1/3 parity is also applicable to an advisory board, as the employee co-determination rules may not be circumvented by a different designation of a supervisory board. If the advisory board is only granted approval rights that are not covered in Section 30G, Para 5 of the GmbH Act, or if no comprehensive supervisory tasks fall within the scope of responsibility of the advisory board, the provisions for the supervisory board are not applicable. So now we will show you the advisory board in the OG and KG. These are types of the partnerships in Austria. Austrian law does not regulate an advisory board. In Austrian partnership, an advisory board can be established as an optional body of the partnership due to the private autonomy. As in the GmbH, there can be a distinction between advisory boards that are close to the shareholders, to the directors, or to the supervisory board. An advisory board under the law of obligations in the partnerships corresponds to the advisory board under the law of obligations in a GmbH. Now have a look at the advisory board close to the shareholders in a partnership. In principle, the limits that also apply to the GmbH must be taken into account. Thus, among other things, the amendment of the Articles of Association, as well as the dissolution of the company, or the decision to dissolve the company, may not be transferred to an advisory board. Furthermore, due to the principle of self-organ capacity, in German it's called das Prinzip der Selbstorganschaft, some difficult German word, may not be transferred to an advisory board. Instructions may only be issued to the directors by the shareholders. The principle of self-organ capacity means that only the shareholders are allowed to fulfill management and representation tasks, as well as these are only allowed to have influence on the management due to their at least partial unlimited liability. In any case, the advisory board can act in a supportive and advisory manner. advisory board close to the directors. Also here is, in this case, the principle of self-organizations, self-organ capacity applies. And of course, I already said it 2 sentences ago, only the shareholders are allowed to fulfill management and representation tasks. So also no management tasks can be transferred to an advisory board. In any case, also, the advisory board can act in a supportive and advisory manner. And let's have a look at the advisory board close to the supervisory board. The supervisory board is non-existent in Austrian partnership law. Due to the private autonomy and freedom to organize the articles of association, an optional supervisory board body can also be established in a partnership. We can call these bodies advisory board as well as supervisory board. The task of such an advisory board in a partnership can be similar to the tasks of a supervisory board in a GmbH. In particular, monitoring tasks as well as the rights of approval. In this case, the principle of self-capacity is not impaired by the establishment of an advisory board. The directors retain the right to initiate management measures. The right of monitoring does not change this, and the right of approval is only an instrument of preventive monitoring. However, a comprehensive right of approval would be inadmissible, as this would undermine the right of initiative of the directors. And there the sentence is said. And now to the special tasks of the advisory board in family businesses. I show you 2 types and the advisory board for company succession. The generational change in the family business is described by some as the Achilles heel of the family business. It therefore makes sense to integrate the advisory board into the generational change. The advisory board can be commissioned to assist in the selection of the new director. Important. In any case, the appointment must be made by the shareholders themselves, and no binding nomination right can be transferred to the advisory board. However, a non-binding nomination right can be transferred if there is no binding of the shareholders of the general meeting. There's no problem to agree these tasks. And the advisory board as mediator and moderator. The moderator in the transition phase. In the transition phase, senior and junior often work together in the management. The advisory board can mediate between the parties in this predecessor and successor conflict as an impartial advisor. Also, shareholder disputes in family business are often associated with emotional conflicts, which can be resolved by an independent expert advisory board as a moderator. The advisory board itself does not make any decision, but only mediates. To put this into a nutshell, here's a short summary. In Austria, there is no legal base for the establishment of an advisory board. It is allowed to establish one because of the freedom of contract and the private autonomy, and the GmbH Act mentions further optional bodies. A distinction can be made between the legal basis for of the establishment, as well as if it is an advisory board close to the directors, close to the shareholders, or close to the supervisory board. And the special tasks of the advisory board in family businesses relate to the company succession, as well as the advisory board as a mediator and moderator. And important, the advisory board as in the company succession, as well as in the as a mediator and moderator. It does not depend if it is an advisory board under the law of obligations or it is an optional body. Thank you for your attention. I hope I can bring you a little bit. Have shown you the special tasks of the advisory board.